Good evening. My name is Cedric Smith, and my case study on defamation. Today we're going to discuss New York Times Company versus Sullivan and Gertz versus Welch. To begin with, what is defamation? Defamation is described as the statement or action that creates harm to a person's reputation. As you may know, there are two forms of defamation: libel and slander. What is libel? Libel is defined as any form of defamation that is written and or published. What is slander? Slander is strictly the verbal statement that hurts the reputation of a person. We're going to go ahead and discuss the first case, which is New York Times Company versus Sullivan. This case was argued January 6, 1964 and decided March 9, 1964 behind an article that was published March 29, 1960 by the New York Times discussing the civil rights issues that were happening in Montgomery, Alabama. Who were the parties and what facts led to their disputes? The plaintiff, LB Commissioner Sullivan, sued the New York Times Company for printing and advertising about the civil rights movement in the South. LB Sullivan testified that he was Commissioner of Public Affairs, and one of his duties was supervisor of the police department, and the article defamed his official conduct. The defendant, the New York Times Company. The New York Times Company published an article on March 29, 1960, titled "Heed Their Rising Voices," that addressed civil rights issues in Montgomery, Alabama, including one which Martin Luther King Jr. was facing a perjury charge. Why did Sullivan feel his reputation damaged by the New York Times publication? Post testified of his position as Commissioner of Public Affairs, in which one of his duties was supervisor of the police department. He felt any police action mentioned was a reflection back on him. All issues that was facing in the article he felt was a reflection on himself and was demeaning his conduct. What are the elements of defamation libel? Since Sullivan was a public official, what did the plaintiff have to prove in this case? The element of libel was article published by the New York Times Company. L.B. Sullivan wanted to ensure that he remained in the positive eye of the community and that the false publications was ruining his reputation with supporters. What was the U.S. Supreme Court decision, and why did it make that decision? The plaintiff, L.B. Sullivan, was granted $500,000 in punitive damages. However, the ruling was in favor of New York Times Company due to lack of proof of malice. The second case that we're going to go over is Gertz versus Welch. Who were the parties to this case? Was a petitioner a private person or public figure? The parties involved Welch, which was the respondent, and Gertz, which was the petitioner. The petitioner was noted a private person. What were the alleged defamatory statements about Gertz in the American Opinion article? The statements about Gertz in the American Opinion article deemed Gertz as lenient and a communist fronter because of his decisions to represent clients who were suing a law enforcement officer. What was done to confirm the accuracy of these allegations against Gertz? Magazine editor admitted via affidavit that confirmation of such allegations were not compelled and that it was still published. How do you think these allegations affected Gertz's reputation? With the type of allegations, it is safe to say he was not looked at the same public eye. He may have lost supporters, business, and following due to allegations. The allegations tie him to the communism and a previous criminal background. What would you have done differently than Welch to avoid the lawsuit? Personally, I would take the necessary steps to validate the allegations made. Because he was a private person, not a public figure, I would have reached out to his following and public eye prior to slandering him reputation to where it is less of a malicious intent. What is my state's defamation law? The state of Florida's defamation law is the defendant published false statement about the plaintiff to a third party, and the false city of statement caused injury to the plaintiff.